My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me about. In lawsuits filed, what happens pending the filing of the lawsuit in a trial by a jury is governed by local court rules that vary from state to state. I'm licensed in Oregon and Washington, and the rules in both states are somewhat different. In Oregon, I'm going to discuss that first because it's the simplest to understand. When the lawsuit is filed, generally it's going to go to trial. If it's tried, not settled before that, it's going to be tried at 1 year from when the case was filed. And in that 1 year, there's some things that happen. The primary thing that happens is the plaintiff and the defendant exchange requests for documents that either one of them may hold, which they have to produce. And your attorney generally puts those documents together, but sometimes the attorney requires the client's help to put those together. And those documents consist primarily of medical records and bills, both for the treatment of the injuries sustained by the client on the case that the attorney is representing the client on, and prior injuries or conditions affecting the part of the body injured in the claim the attorney is representing the client on. And it's necessary to put all those things together. There's other things that are requested too, like vehicle estimates in auto cases for damages and things like that. So once those items are exchanged, the other major things that happen are that the client is expected to attend a deposition conducted by the defense attorney, and the client may be required to attend a medical exam by a physician bought and paid for by the insurance company. The insurance companies like to refer to those examinations as independent medical examinations, but they're not independent. The doctors that conduct those examinations overwhelmingly understand they're conducting them for an insurance company, and that is reflected in the opinions that they offer about the condition of the plaintiff. But the first thing we want to talk about is the deposition. A deposition is simply a proceeding in which the injured party, the plaintiff, sits down at a conference table with that person's attorney and the attorney for whoever has been sued. In other words, who has been sued is the person who caused the injury to my client. And that attorney is then allowed to question my client about how they were injured and about their medical condition and other things germane to the case. It's generally an informal proceeding. In other words, it's generally conducted in an attorney's office. Frequently it's my office, and the only people present are the two attorneys, the witness, and a court reporter. Now, the court reporter is taking down everything that's said in notes from which the court reporter can prepare a verbatim transcript of what's said, and that verbatim transcript can be provided at trial and actually read into the record at trial, or it can be used to, if the witness contradicts their testimony at trial, to confront the witness with what they said in deposition and ask them about any inconsistencies. Sometimes my clients are nervous about depositions because of the things I just said. There's really nothing to be nervous about. It's very informal. I sit my clients down and talk to them about what's involved and try to explain to them how they approach it. And of course, the biggest thing is that they tell the complete truth and try and be as accurate as they can with their answers and let the chips fall where they may. So that's what a deposition is. And the plaintiff's deposition is usually taken. However, the deposition of the party that caused the injury, or a police officer who investigated, or any number of people can be deposed. Sometimes doctors who have treated the patient are deposed. Sometimes doctors who did a so-called independent medical examination are deposed. And so that's what happens. And in Oregon, when all those things have happened and the trial date comes up, then the case is tried. By the way, most cases that are filed as lawsuits are settled before there's a trial. Now in Washington, it's a little bit different, and this is the difference. In Washington, the defense can take the deposition of the plaintiff's doctors and other expert witnesses and can take that information and use it at trial. In Oregon, they can't do that generally. In Washington, it's a much more transparent process. The access to the information is much greater, and also it's sometimes quite a bit more expensive. And the reason it's more expensive is if the depositions are taken of doctors who have either treated my client or who have examined my client for an insurance company, those doctors are entitled to compensation for attending a deposition, and they charge a lot of money, and it's generally got to be paid in advance. But in any event, that's kind of the process that's followed. Sometimes there's motions that are made in the court by the attorneys, as for instance a motion for summary judgment, by which the attorney asks the court to rule as a matter of law that one party or the other is entitled to recover and win the case without there ever being a trial, because there's no material issue of fact in dispute, and the case can be resolved without having a jury. That doesn't happen very often, but it does happen. And sometimes the court will grant what's called a partial summary judgment, in which case they'll find for one party or the other. And that happens frequently when the person who's injured makes a motion for summary judgment on the issue of liability and asks the court to determine that the party that caused the injury did in fact cause the injury, in which case at trial the jury is instructed that the determination that the other person is at fault has already been made. And then there's other technical motions I won't go into that are frequently argued, but in any event, that should give you kind of a thumbnail sketch of what happens if a case is tried. If you're interested in talking to me about any of these issues, feel free to give me a call. It's nice talking to you this afternoon.